So while our next speakers come up, Anat Rosenberg, I think, is the only person from my session that does need introduction, merely because she's the youngest in her professional life of the others. So, but I think the best introduction is to say that I didn't let her ask a question to Simon, and this is the kind of person that would rather ask a question to Simon and take up time from her paper. So, I hope her friends who won her in the IDC appreciate how fortunate they are. Please.
Thank you. It's the second time it's happening to me today. I don't know what is it with me today. First a chance to say thanks again to all of you for being here. It's been a wonderful almost 2 days, and thanks again to my great, supportive, resourceful co-organizers. It's been great. And the second preliminary is an apology to any of you who have been diligent enough to download my paper before June. I switched versions. Whatever clarity means, this version is hopefully that. But there you go. So I'll try to say a few things about. I'll quickly recall the argument and then say a few things about methodology as well. Right. So substantively, this essay's legal focus is the doctrine of necessaries. The doctrine regulated domestic consumption by enabling married women to buy consumer goods on their husband's credit. Right? And I want to basically forward two claims with respect to the doctrine. The first claim is that a new conceptualization of consumption emerged through the doctrine in the second half of the 19th century and became dominant in legal analysis. Right? The traditional way to make sense of consumption had been through what I call, after Alan Hunt, the order of appearances. Right? Commodities were matched to persons according to class and gender hierarchies. This was navigated in turn through concepts of luxuriousness. Right? The new way to think about consumption was through notions of rational budget management within the imaginary of household routine. This way was more banal, to my mind, than the order of appearances. I'll come back to that. But it got rid of the enormous historical weight of luxury critique. Right? As long as you were within your budget, you were free from the moral critique embedded in notions of luxuriousness. I think that this move opened a route, if you will, to a late modern consumerism, to an indiscriminating culture of consumption in which anything and everything basically goes. Right? Now, I want to emphasize something which is perhaps not obvious in the paper or not emphasized enough, which is that the rationality of household budgeting became a dominant conceptualization, but I don't mean to say that it was exclusive or free from ambiguities, just important enough to be noticed. So this is one substantive claim, right? A shift occurs in the way consumption is imagined, made sense of, evaluated, and channeled, and I use channeled purposively in the paper. I view this move as having constitutive effects on consumer activity. Okay. The second claim has to do with the sentiments fueling change. The irony for me is that the turn to consumerism was not premised on a disavowal of discipline, right? This was not a celebration of consumerist fun. Instead, the change was fueled by fears of expanding consumption. The new conceptualization of rational budgeting was the result of a pretty anxious search for new disciplines for the working classes and for women consumers. They just seemed to get out of control, right? In the essay, I describe this as an attempted containment of consumer activity. Budget rationality was an idea which limited foremost the consumption of those who were limited to small wages, that is, the working classes. Household routines was an idea which constrained women whose social role was still predominantly managing household. Now, all these concerns with working classes and with women consumers, and the attempts to contain and delimit their consumer activity were, to my mind, poignantly captured by Gissing's Eve's Ransom. I rely on the novel as an interpretive framework for my reading of legal developments, and something else which is not actually said in the essay, but I think that the legal analysis also illuminates the novel and points to some discussions which does not explicitly address, but which are interesting in reading it. Now, why is the irony that I mentioned interesting? Why is it interesting that a turn to consumerism was based mostly on fears, right? I mentioned some explanations in the paper, but something that I don't mention there and is actually important to me is understanding historical processes of change and repetition. Right? The 19th century is intriguing in that you see many processes which represented significant historical change in the social order, and yet these processes preserved forms of social hierarchy which were not analytically relevant anymore, supposedly, right? Class and gender appear to be analytically irrelevant to household budgeting, yet that abstraction was tailor-made for them, and so it preserved those hierarchies while at the same time altering them by denying that they were the explanation or the goal of the analysis. And so this is a layered form of change which I've tried to write about before and is fascinating to me. Right, so that's on the substantive side. I'm going to say a few things about method, right? Just to be responsive to our call for papers. I think the issue is going to look different. Legal aesthetics and the sacred seem to me to be important themes coming out of this conference, and we should reorient the issue there. But nonetheless, a few things about art and legal history. So I rely on familiar sources of legal history, some more elite, some more popular, and I rely on an interpretive framework guided by Gissing's novel. I view this as a book project, a beginning of a book project, hopefully a cultural legal history of consumer law. And what I would like to do is look at a few legal aspects of consumer credit or possibly other areas of consumer law and see whether the change that I'm tracing here resonates, right? Works in other areas of law as well. And what I'd like to do is write each chapter together with a novel of this era. So I was telling Nan and Simon that, the next thing I've started to think about is the 1869 Debtors Act together with the picture of Dorian Gray. So I'm playing with this plan, right? Now, this methodology is meaningful for me on any number of levels, and I'll just mention two which hopefully exceed my own subjective preferences, abilities, whatever. So first, it seems to me that connections and juxtapositions of close readings in literature, together with analysis of legal materials, often opens up unexpected angles on historical change. And I'm still unsure why, right? I mean, I think this is a big question. Why do art seem to add something which is not otherwise available? What is it? Assuming that we discard sentimental accounts of art, which I don't particularly like. So maybe it's the difference. Maybe it's a difference in genre, which yields difference in practices of interpretation for legal and artistic sources, right? Maybe that's the source of fruitfulness there. The assumptions which guided the way particular legal and literary materials were created in the 19th century and which guide the ways that they are now approached and read are different in ways which are fruitfully challenging from my perspective. Now, needless to say, there's nothing essential here, right? It's just the history of genres and disciplines and the way they develop in late modernity, which was partly relational. I mean, genres were developed vis-a-vis one another in ways which yield this. So art's seemingly less functional social location, its seeming distance from state mechanisms, its less hard-nosed self-image and so forth, all of these invite a different kind of conceptual play from that typical of legal analysis, and in consequence the juxtaposition seems productive. Because I think that historical differences between genres might be the reason that artistic sources are fruitful in legal history, I don't tend to completely erase the law-art differentiation. of course, I treat them as similar in many ways. I mean, I view this as a cultural history, so for me, all of my sources are sites of cultural production. They are unstable perceptions and meditations on human complexity, the bottom line. But I prefer to work with disciplinary and historical differentiations, at least at the outset, in the way I read sources, right? Because there's a history of genres. Okay. And not only a history of substantive questions like consumption, generic differentiations should, I think, be confronted in the way we read, even if only to be challenged, right, which should sometimes be done. Okay, one other reason that I like the use of law and arts actually relates to your paper, Simon. There seems to be at least a potential here for a change in the aesthetics of writing law or writing about law. I don't know that the difference is clear, right? So to put otherwise, these things, mixing certain genres and interpretive practices potentially prods aesthetic conventions embedded in law and in historical legal scholarship. And the question then becomes, why prod them, right? I want to air a speculative thought. It is speculative, but where else would I air it, right? So during work on this project, I've come to the tentative conclusion that part of the way law operates ideologically in regard to consumption after the mid-19th century is by being boring, okay? I hope to write about that separately, but in any event, to expand toward what Simon was saying and risk a broader hypothesis, it seems to me that paradigms of rationality, right, operate aesthetically to bore, right? That is, to lull people into a doze and lower their levels of attention. But I'm serious, actually. So that is done by taking excitement away. And I don't mean some popular notion of what's boring, what's not boring. I mean formal removal of things which excite, like removing elements like sensuality, surprise, mystery, humor, right? A lot of things that are missing. And so boredom seems to be an important analytic category to me. So I'm not going to get into this right now, but I'm airing it in order to say that this might be another way to think about the arts in legal history beyond the fact that bringing them in might be fun or interesting or insightful, which are all important, right? Expanding the array of aesthetic reading experiences in scholarship might be a form of self-reflection on how we operate to convince, that is, on the relation between aesthetics and politics in law. So I'll stop here with this myriad thought.